Dear Lord, we thank you for this day. We pray for the important business before us. We pray for people of Georgia, all 11 million, and just pray for wisdom and discernment as we approach crossover day and the business day. In Christ's name, amen.
Thank you. Notes.
All right. Thank you.
All right.
All right, folks. We have, just so you understand the situation, I've got several members of the committee that are on rules. Rules starts at 9 o'clock. I've got about an hour to do this bill. So I got to limit audience testimony to about 5 minutes at the most. So just to let you know that things are running rapid until we get up to crossover, so it's going to be hard to get a lot of stuff done normally, like we normally do. So, Representative Carpenter, if you would talk about your bill.
Ladies and gentlemen, I come before you today to present House Bill 211. Most of you guys know in this room that I usually come with a joke in hand to lighten the mood. However, this legislation is no laughing matter. It's about protecting 50,000 jobs in Northwest Georgia and hundreds of thousands across the state. You're going to hear a lot of talk from chemists and attorneys, and I am neither. However, I can see the implications playing out in front of my very eyes. It became apparent to me last spring that this was an issue that, if not dealt with, would be devastating to manufacturing and our Georgia manufacturers in the state of Georgia. As out-of-state attorneys join forces with in-state attorneys to file lawsuits against our community and the businesses in my community. These forever chemicals were created mostly by two manufacturers. This legislation seeks to focus attention on these chemical manufacturers. They created these products. They sold them as safe. The federal government agreed that they were safe, and now the goalposts have been moved tremendously on the manufacturing community. They use these products as directed and now face endless litigation. We are now in the posture that we're all going to be suing each other, and when that happens, nobody wins. We heard throughout COVID how important it was to protect lives and livelihoods by Governor Kemp. That's what this bill simply is trying to do, to make sure that the individuals who have been injured have the opportunity to address that injury. It also clarifies that the EPD will be involved in the cleanup when the federal government determines the path forward on these chemicals. It focuses the attention of the litigation on the chemical companies and any company that willfully neglected protecting consumers in regards to these chemicals. The majority of the people in this room know I'm an individual who loves all people, people of all races, people of all economic status. I have spent my legislative career fighting to help people. House Bill 211 is no different. Millions in litigation expenses will not help with cancer and will not help with cleanup. And that's why I sit in front of you today. I know we have a lot of people here today, and if it's okay with you guys, I'm going to have a gentleman next to me go through the bill. And I'll take questions at the end if that's okay.
All right, if you would introduce yourself and go through it.
Thank you, Mr. Chairman. And my name is Mark Rogers. I'm a Deputy General Counsel for Litigation at Mohawk. And I'm going to use Mohawk as shorthand for a bunch of different subsidiaries, so don't hold it against me if I've got not making distinguishments among the different companies. You want me to just do the bill first? You want me to do the speech?
No, I don't care. You're
okay, very good. So I just want to give a little context of Mohawk. We're a 30,000 employee plus worldwide company in the 6 northwestern states of Bartow, Chattooga, Floyd, Gordon, Murray, and Whitfield counties. We've got about 7,000 employees. Those 7,000 employees were paid over the last 2 years about $1 billion in compensation. So that inures to the benefit of the state and the taxes the state gets. We paid vendors about another $1 billion in additional economic activity. Our property and sales taxes and corporate income taxes were another $35 million. So that's just one company up there generating all that economic activity. And these lawsuits are a risk for the company, and so that's why we're here. The first thing I want to do is actually quote from some of the lawsuits against the company. So this is a paragraph from one of the lawsuits by a landowner, and they say that the chemical companies have long been aware that PFAS are environmentally persistent, accumulate in the human body, and are toxic, including PFOA and PFOS and the short chain compounds introduced to replace them. The defendants, nonetheless, and that's the chemical companies, knowingly and intentionally sold and continued to sell PFAS and PFAS-containing products to the carpet manufacturers in Calhoun. The defendants did so without adequate warnings of their dangers when they knew or should have known what would happen to the environment by the discharge to the public wastewater treatment plants, including the Calhoun WPCP, where they would inevitably concentrate in the sludge applied to the properties adjacent or proximate to the plaintiff's property. So the plaintiffs in these cases allege that the carpet mills didn't know. And another one, lawsuit, this is by the city of Calhoun. For decades, the PFAS manufacturing defendants, that's the chemical companies, sold PFAS chemicals to the carpet manufacturers in Gordon County and Calhoun without adequate warnings of the environmental and human health dangers associated with their products, which includes danger to human health, environmentally persistent, bioaccumulative, and highly mobile in water bodies. The PFAS manufacturing defendants knew that PFAS tainted wastewater and could not be properly disposed of without sophisticated pretreatment equipment, etc. So the plaintiffs in the cases against the manufacturers acknowledged that we weren't told about the dangers. I would like to say a little bit what the chemical companies actually told us. And so in a letter from 2000, 3M said that they were moving away from the PFOS chemistry and said, while the chemistry has been effectively used for more than 40 years and our products are safe, our decision to phase out our production is based on 3M's principles of responsible environmental management. And DuPont followed that up right with a letter that said, 3M decided to discontinue their Scotchgard products. We'd like to clarify that our products, you can be confident that the soil-resistant and stain-repellent and surfactant products supplied to you by DuPont are safe. And then in 2006, DuPont sent another letter to the carpet mills, addressed to the carpet mills, saying, you may have received a flyer from the United Steelworkers Union with inaccurate information about products made with DuPont fluorotelmer chemistry. The USW continues to allege these products may be harmful to you, your customers, and consumers. This is simply not true. So that is the background that the carpet mills were dealing with in the 2000s and on, when it came to their use of the various chemicals supplied by the chemical companies. And so then to the bill, which we appreciate Representative Carpenter, as well as Representatives Ridley, Tarvin, Barton, and Cameron, who are all from Northwest Georgia, who recognize the importance of protecting the industry up there. And so the bill basically, just to contextualize it for a second, it divides the world into three types of people. There's people who make the chemicals, there's the people who received and used the chemicals in industry, and then there's the cities and counties who had to clean the water, provide clean drinking water, receive landfill materials. The bill would protect people in the middle and bottom category. So it protects the people who received and applied the chemicals in their businesses, who didn't know, and the people who are cleaning it up afterwards. So they're not suing each other anymore. That's what the intent of the bill. And so the bill has some definitions. The definition of PFAS is broadly defined in the bill, and that definition actually comes directly from the lawsuits against the manufacturers. So that is the definition used in the lawsuits suing the parties. And so that's why it is drafted as broad as it is. The statute has a willful misconduct provision, and that's a definition that was lifted from the workers' compensation willful misconduct statute. And the case is interpreting that definition to provide context for, when the shield would not apply. And then the shield itself is pretty simple. It just protects people who are in the second and third categories, who received the products and have to clean it up, from litigation right now. without willful misconduct. That would be an exception. And the other thing the bill provides is that there's no, the shield wouldn't apply to personal injury claims. So if there's anybody who's going to bring a personal injury claim, they can sue whoever they'd like about it. This bill does not alter or adjust those claims. It also doesn't adjust the right of the EPD to regulate. And that, I think, is the intent of the bill, is to allow space for the regulators to do their job with respect to the second and third levels. The bill has received an amendment from the professional engineers, and they're going to talk in a little bit, but they've also been sued for providing advice to landfills and then not adequately anticipating the risks of PFAS. So this is trying to protect the people who are trying to help deal with what the chemical companies have given to us. So, I've heard concerns that we're adjusting the rights of parties midstream. I would just refer the committee to Title 51 and Chapter 14 of that, the last 3 chapters that were added. Chapter 14 adjusted the rights as regard to asbestos and silica cases. That was adjusted after those cases started coming. Chapter 15 adjusted asbestos again, so you can revisit what you've done. And Chapter 16 adjusted claims to COVID. So the idea that we can't move things midstream is not actually with the history of what this committee has done in Title 51 in the past. So I'm happy to take questions, and I thank you very much for your consideration of the bill.
All right, any questions? What number is it? It's not lighting up.
So, can you hear me?
16.
Okay, got it.
Thank you, Mr. Chairman. So, it's my understanding that these chemicals are in lots of products, and I was just curious, what are the range of products are we talking about PFAS is involved in?
So there's some really comprehensive articles out there, but it ranges from everything from agricultural fertilizers, the chemical fertilizers that are used in farming. It's what renders makeup waterproof. If you have waterproof makeup, it's, at least historically, the properties were based in that. I understand that it's used in many industries. And I know that pulp and paper has been dragged into this. I'm not familiar with how they used the chemicals, but it's in that industry as well. It was in pizza box tops to keep the cheese from sticking to pizza boxes. It was in hamburger wrappers to keep hamburgers from sticking to hamburgers. It's in paper straws to make paper straws. It was in the masks we wore for 3 years during COVID. It's in everything. I mean, it's almost literally in everything.
And so, I know a lot of the cases you're referencing were 2006, 2007, so has this become a more apparent danger more recently?
So at the beginning of 2024, I had 4 PFAS-related cases, and right now I have about 20. And so these cases, the first case that I was involved in, my company was involved, started in 2016, over in Alabama, and it's it's just the litigation has proliferated. I now have cases in Georgia and Alabama and South Carolina, and a case in Tennessee actually. So. There's a wide range. I should say that, federal law still provides additional remedies. So if you have a CERCLA claim, you can bring a claim under the CERCLA Superfund site. There's lots of other ways to achieve the ends here. I'm being sued for nuisance and trespass and what's the last one? Anyway, they're common law claims that are being asserted in these cases.
What does the federal EPA say about these chemicals versus Georgia EPD?
Well, so I understand the EPD generally follows the EPA's lead, and where the EPA is right now is they've put 2 of the chemicals, PFOS and PFOA, on the hazardous substance list. So they would be susceptible to a CERCLA Superfund claim, and Dalton has asserted such a Superfund claim in federal district court in the Northern District of Georgia. There is a drinking water rule that applies to those 2 8-chain carbon, and we can do the science if we like, but those PFOS and PFOA, and then I think it's 4 additional, might be 6 additional, what are called short chain, which is the fewer than 8 carbons in them for drinking water. And so that rule has gone final. There was a rule on wastewater treatment that the Trump administration has put a pause on. And I understand that there are challenges to the hazardous substance designation in federal court. So I'm not following that very closely, but that's where EPA is.
Have they found any direct correlation with carcinogens or a direct relationship to that?
The EPA has, I think the phrase they use is a likely carcinogen. You know, like I understand that likely carcinogen is not actually as likely sounds, but I'm not an expert in the various ways the EPA categorizes those type of chemicals. I do not believe they found it causative. That's not the EPA's determination, but again, I'm going to defer to others to speak on that. Yes, ma'am. Thank you.
And just so we're clear, the standard went from 70 parts per trillion to 0.004 parts per trillion as of last April. That would be like a raindrop hitting your Gore-Tex coat running off, and now your house is transmitting PFAS into the wastewater system. So it's an absurd number where we're at in the world. So.
Okay. Representative Oliver, is that you?
Thank you, Mr. Chairman. I'm not familiar with this litigation. I'm a little bit familiar with asbestos because I think I was involved in some of those legislative efforts a long time ago. If PFAS is still being sold and still being used by what you describe as the middleman, and have any cases against the carpet industry in Georgia ended with a verdict against them?
No, ma'am, and you know, the first case it was in Alabama, and we were having the jury fill out the questionnaires, and my company was the last one left to try to defend the whole thing. And so, if I have to defend the chemical company's science, I'm in a really tough position. And so that is how these cases all end up settling, is that, you know, the people who received the chemicals have to end up defending the chemical companies in those cases, and that's a heavy lift for us.
Ms. Silcott's questions were helpful to me. This bill creates immunity for any middleman user or only the carpet folks?
Right now, it's broadly written because the view from the bill's sponsor was this is going to go to every industry in the state, and those industries deserve the same protection before they get hit.
And these products are still being sold by the chemical companies and still being used by the middlemen. Middleman is kind of a broad term, and forgive me if that's not accurate.
Well, so my company no longer intentionally buys PFAS products, and we're not applying them for those properties any longer. I'm sure there are industries where these things are essential. So, you know, I think that, you know, they form like the seals in aircrafts, and they help, you know, make gaskets in planes more safe. Right, that might be a use that people could tolerate. There are bills around the country that try to delineate approved and disapproved uses of these materials on a going forward basis. So Maine has a law like that. There are other states that have laws like that.
Has any other state granted a total immunity to the user?
I think we are the bleeding edge of this effort.
Thank you.
Yes, ma'am.
Chairman Smith?
Yes. Thank you for being here. Good to see you again. You were talking about water earlier. Is this really akin to what we're dealing with the Camp Lejeune poisoned water?
You know, I am not as familiar. I thought it was a different chemical, but I do believe that there are PFAS aspects to what's going on. The military used what's called AFFF, or aqueous firefighting foam, to put out, you know, propellant fires, and the aqueous firefighting foam is highly, the percentage of PFAS in that material is very high.
Okay, thank you.
Number 5 over there, is that you? Representative Mohawk.
Thank you, Mr. Chairman, and thank y'all for coming this morning. We've had plenty of discussion, both in the committee and out, about this issue. I will say, you said about paper straws. I'll submit to this committee that anyone who manufactures a paper straw has what's coming to them. I wanted to ask you a question about, let's see, what I find out. On line 43, it's a definition here. It says, molecule received by others for application or use in agriculture. Now, But y'all manufacturing carpet, is that correct?
We manufacture a wide range of products, but carpet is among them.
Carpet, flooring, things like that.
Yes, sir.
What was the intention of having agriculture? I think that food or agriculture is probably even a higher bar than surfaces. So kind of maybe explain to me why y'all wanted agriculture to be included.
I believe that it affect is it Grazon? I'm not a farmer, but it is in agricultural products. You've sprayed it on your yard before, you just don't realize it. It's in the chemicals that you're putting on your yard.
Yeah, I understand it's in both pesticides and fertilizers. And so, I think the intent of the bill is to protect people from these regulatory lawsuits about regulation, to defer to the regulators. And so agriculture has regulators, they can act, but you would protect farmers from a nuisance claim, not a personal injury claim, right? So the personal injury claim still survives, but claims that are environmental in nature or that are regulatory in nature, those are the kinds of claims that I believe the representative is intending for the regulators to address first, rather than addressing it in litigation as a precursor to regulation.
But you yourself and your company has no interest in agriculture.
No, sir.
So that is not important to you specifically.
No,
correct?
sir. Correct.
And Mr. Chairman, if I will, I hope that we have somebody who's here to advocate on behalf of. I would just like to know from the agriculture folks why that's in here, if they're here. But I guess we'll get there when they sign up. Yes, sir. Thank you, Mr. Chairman. Appreciate that.
Thank you, Mr. Chairman. Sorry for being late. I was presenting an appropriations, got down here as fast as I could. I assume, both from the author and your perspective, that the premises coming for this bill is we didn't know. We didn't know this was dangerous. And I want to know from the author what he did to satisfy himself that that was true, and whether you've got a person from the actual company as opposed to a lawyer paid to be an advocate who will come down here and say, we're not under oath, but sort of under oath, we had no idea. Because if that's not true, I have a hard time understanding why we should consider this legislation.
Yeah, I mean, I think that's a fair argument, and I'm sure I can find a bunch of people that will come down and speak to that. And I think that, we live in a country where you're innocent until proven guilty, and if a man and a series of men come to this committee and say, we didn't know, the chemicals companies told us it was safe, the federal government told us it was safe, how can we be liable? I mean, at some point, let's focus litigation on the bad actors.
Well, I think, Representative, the history has shown that industry finds out about things and has research and development that's sometimes a lot ahead of our federal government. And that was true with cigarettes. It's been true. I mean, I could go down the list. And so what I'm interested in is some definitive representation that industry truly had no idea that this was unsafe. Because if that's not true, then you're coming down here and asking for immunity for something that you knew was dangerous to consumers, regardless of what regulators were doing. I mean, we want regulators to do their job too, but if industry knew, what is the rationale for a get out of jail free card? That's my question.
Well, I think you brought a good point up when you brought up cigarettes. So when we found out cigarettes cause cancer, I don't believe that attorneys lined up to sue the gas stations that were selling them, the box companies that made the boxes that the cigarettes went in, the newspapers that advertised cigarettes. Like, at some point, let's focus litigation on the people that created it and lied to everybody. A whistleblower with the chemical companies came out and said, we knew and we didn't tell anybody. The gentleman beside me has letters that prove the chemical companies lied to them. I mean, where does it stop?
But is it true or not true that the carpet companies disposed of PFAS in the ground? That gas stations weren't putting dangerous chemicals in the ground related to cigarettes. So that analogy just doesn't hold. And am I right or not right about that, about what carpet companies were doing with the PFAS materials?
The carpet companies followed the direction of the manufacturer and the federal standards for discharging the chemical wastewater.
But what have you done, Representative, to satisfy yourself that the carpet industry did not have any knowledge, did not have any warning itself, regardless of the manufacturers, regardless of regulation, that dumping into the ground could be hazardous to the great residents of Northwest Georgia? That's my question.
Thousands of conversations since Aaron Brockovich showed up in my county in, I think, May of last year, June of last year.
Have you personally reviewed any documents, spent time?
I have not personally reviewed any documents. And if you find that there's willful misconduct, sue them all. I don't have a problem with that. If they intentionally knew that there was something wrong with these chemicals and they tried to hurt the citizens of my community and the citizens that live beneath my community and in Rome, etc., then sue them all. But I contend that is not the case.
Yes, thank you, Mr. Chairman.
Thank you, Mr. Chairman. Thank you for this exchange, but my question really goes to the questions that the member was just asking previously. If there's it looks to me like if there was a circumstance in which there was knowledge, then this wouldn't apply. This treatment wouldn't apply. So either if there was not, those lines 49 to 50, sir, isn't it true that it says if there's knowledge that it's likely to result in serious injury, or knowingly wanton and reckless disregard of the probable consequences? So the circumstance that you were just asked about, if there was knowledge and what the sponsor knows, his investigation into that, those circumstances wouldn't apply in this situation because that is willful misconduct as defined by the bill, and therefore any unique treatment under the circumstances contemplated in this bill wouldn't apply. Am I understanding this correct?
That is correct.
Thank you.
Thank you, Mr. Chairman. And my line of question goes to the previous representatives, and I just kind of want to get a better understanding that we are saying on line 55, absent willful misconduct. I would like I think you would be the person to answer this. Why should that be the applicable standard here? I heard you reference workers' compensation and that definition coming from the workers' compensation standard.
Sure. So, I was asked to, there was feedback given to the representative about the bill being overbroad, and that idea would be willful misconduct should be a exception to the shield. And so I tried to figure out, well, where's this idea of willful misconduct come from? And the place I could find it was just that word has been most robustly interpreted, that clause, in the workers' compensation context. So I was saying that the courts have construed that clause, and the definition comes from that area, not that there's a particular relationship between those claims and these claims.
And I'm going to ask a follow-up. If that's a pretty high standard, so if willful misconduct is the standard, how would that future companies, if they know information, as long as it's not willful, this would protect them from suit?
The idea is to provide the space for the regulators to act in these non-personal injury contexts. That's right.
Okay. Thank you.
That appears to be all the members' questions. Making sure. All right, so now we're going to go down the list. Folks, I'm going to have to limit it to about 3 minutes apiece. And I have a timer. And if it goes off, if you could, please wrap it up as quickly as possible. All right. All right, first one up, April Lipscomb.
All right. Morning, Mr. Chairman. Morning, members of the committee. My name is April Lipscomb. I'm a senior attorney with the Southern Environmental Law Center, and we are a nonprofit environmental advocacy organization. We've been working on PFAS issues for quite a long time in the 6 states that we work in, just to provide a little bit of additional context. So, these chemicals, there are over 10,000 of them, right? And they've been used since the 1940s in stain-resistant carpet, water-resistant clothing, nonstick cookware, personal care products, food packaging, firefighter foams. They are everywhere. I think I can say with confidence that every single person in this room has measurable levels of PFAS in your blood. So 98% of Americans have PFAS in their blood. The USGS has estimated that about 20% of private wells in America have PFAS contamination in them. And due to their chemical nature, they stay in the environment for a very, very long time. So they don't break down. They build up in animals, plants, soils, water, etc. So, as I said, my organization, we've been advocating for manufacturers and businesses to stop using and making these chemicals wherever they can. And our goal is to stop the chemicals at their source, right, so that they don't make their way into our drinking water systems. EPD has been looking at drinking water systems in Georgia, and they have found PFAS at levels higher than what EPA says is safe in a number of public drinking water systems throughout the state. And they haven't even started looking at just what's in our river systems. So the main reason we are concerned about this bill is because it disincentivizes industrial corporations from discontinuing the use of these products. If they know they're not going to be held liable, then there's no reason for them to stop using them. And that's a big deal for us because this is a big problem, and it's going to take all of us working together to try to figure out how to solve this problem and how to get these chemicals out of our drinking water, out of our river systems, and out of ourselves. So some other specific concerns on this bill. We believe that it's overbroad. This doesn't just apply to the carpet manufacturers. It applies to all industrial users all over the state, right? So, we've heard a lot about whether the carpet manufacturers knew that PFAS were harmful. What about all the other industrial users who use these products in their manufacturing systems? We don't have any people from those companies talking to us about that. Also, the question of knowledge, that's being litigated right now, right? We have plaintiffs arguing that they maybe knew, maybe they didn't know. The carpet manufacturers are saying they didn't know. That question should be decided by a court. We don't have all the facts here. That's not a question that should be decided by the legislature right now. So if anything, this bill is premature, and we should wait and figure out what's going to happen next as these cases move forward. So I'll also say this on the knowledge. There have been studies showing the toxicity of these chemicals going back to the 1990s and early 2000s. It was listed as a likely carcinogen back in 2005. So I'll just let y'all kind of think on that for a minute. And just, Mr. Chairman, I think I have the right bill I'm looking at. Is it LC 443092S? Is that what I have?
443128 ERS.
Totally different one. You don't have it either? Well, the bill that I looked at, thank you.
Brock's got it. That thing's been printed in 17 different versions, so I don't.
I understand. There was. Okay. The other two concerns, and because I'm a lawyer, I had to nitpick the actual language, and this is my last
point.
point.
And you're way over the time,
Oh,
too.
I'm sorry. I'll just quickly highlight them. A plaintiff shall plead facts with particularity sufficient to demonstrate willful misconduct. That's a high burden for a plaintiff without having to go through discovery. It's also a question of law to be decided by a court. That really should be a question of fact for the jury. So
Okay.
I would urge you not to pass this bill out of committee.
All right, thank you.
Thank you.
Dan Snipes. All right, thank you. Ben Finley.
Come on in here, Benny. Thank you, Mr. Chairman.
Yes, sir.
Members of this committee, I'm Ben Finley. I'm going to speak very quickly because I've got 3 minutes, just very quickly. I am an attorney in Georgia. I've been practicing law for 33 years. I'm a special assistant attorney general for the state of Georgia. I represent the state of Georgia, and I represent a lot of folks in northwest Georgia. House Bill 211 is a terrible bill. It is to protect wrongdoers. The bill seeks to immunize carpet manufacturers for negligence, gross negligence, and wanton carelessness. Shaw and Mohawk, among others, have put corporate greed and profit over human lives and safety, and I can prove it today. I've heard, among others, the sponsor of the bill say, and I quote, "Sue them all if there is knowledge." excellent questions were raised about whether or not Shaw and Mohawk had knowledge about these issues. Shaw and Mohawk's corporate representatives have testified under oath that they had knowledge of PFAS contamination for the past couple decades, and both companies were instructed by 3M to incinerate PFAS, but chose not to do so. They could have captured and killed PFAS on the factory floor, but they did not. They chose to discharge it, and it is because of Shaw and Mohawk that it hit the ground in Georgia. 3M made it. They gave it to Shaw and Mohawk, and the monies that Mohawk has made with their $7.6 billion market cap came from PFAS and stepping on the necks and the backs of people in northwest Georgia that they made a profit off of and contaminated our environment. It's called a predominance of cancers in people. It's resulted in properties being devalued, and it is absolutely tragic what has happened. Shaw and Mohawk and 3M representatives have testified under oath, including Jim Williams at Mohawk, Rick Ressler, Robert Chadd at 3M, Kelly Ballou at Shaw, Donald Davis, Jeffrey Loberbaum, Mohawk, and Cynthia Williams at Shaw, that they knew about it, had knowledge of it, and were aware of the problems with PFAS. It is absolutely tragic that this claim is going on. Let me tell you what this is about. This is about the fact that Troutman Pepper filed a lawsuit on behalf of Dalton Utilities and the taxpayers in Dalton to get remediation from Shaw and Mohawk, who have been corrupting and contaminating Dalton, Georgia, and they know they got to clean it up. It's analogous to if I came to somebody's yard and I dumped a bunch of trash in your yard, I can't say, hey man, it's your problem. You got to clean it up. And here's the bottom line. If 3M and Daikin and DuPont don't clean it up with Shaw and Mohawk, it falls on the taxpayers of Georgia. I've been coming up here since I was 18 years old with Pete Robinson from Columbus, Georgia in 1984. I'm 58 years old. I've never seen anything like this where any corporate defendant, and I was taught better, tries to seek immunity and a walk-off home run when they are culpable, have knowledge, and are liable for these claims. It is absolutely tragic. And I would suggest that a law firm like Troutman Pepper with Chief Justice Harold Melton as one of the partners in that firm would never file a lawsuit against Shaw and Mohawk unless they do dadgum well on behalf of the city of Dalton that they had the goods on them. I'm from Columbus, Georgia. It'd be like the dang city of Columbus suing Aflac. And I can assure you the city of Columbus would never sue Aflac unless they had the information, the knowledge, and all the evidence to back up their case. So to quote the sponsor of the bill, sue them all. And that's what we're doing. We sued them all in Gwinnett County State Court. We brought a case with Gerald Davidson in Gwinnett County, a great lawyer in Gwinnett. We've got Georgia plaintiffs against Georgia resident defendants, including Murray County's landfill, Catoosa's landfill, and Gordon County's landfill, because it's going to fall on the taxpayers. And here's the tragedy. The double tragedy is that the victims are going to be have to clean it up. Get a load of that. They dump the stuff on your property, and then you get to clean it up. All right, so we brought against Georgia resident defendants in Georgia State Court on behalf of Georgians, because here we are here truly to protect Georgia citizens, which everybody in this body was elected to do. We stand in unison and harmony, and I appreciate the questions before related to that. I could talk all day about this. I'm happy to field any questions that anybody may have. And I'm sorry if I went over my time.
All right. Any questions? Chairman, Vice Chair Reeves.
Thank you for coming. Has there been a case filed in Savannah recently also?
Yes, sir.
Okay. No more questions.
That
Thank
is.
you.
All right, thank you.
All right, Andy Davis. Oh my goodness.
Mr. Chair,
All right.
I bring you evidence. I bring you background because I'm Andy Davis. I represent the city of Rome. I also represent Somerville, Chatsworth, and I represent the city of Calhoun in these water cases. And Mr. Rogers from Mohawk is well aware. He's a neighbor, he's a friend. But I bring you these notebooks because there's information in them. House Bill 211 and its substitute of LC 443128 ERS is attempting to interfere with ongoing litigation. There's litigation right now in the state courts. The town of Lyerly has a water case. Mohawk is not a defendant. Mohawk is a defendant in that case. The city of Somerville has a case that's pending in federal court in Rome. Mohawk is not a defendant in that case. The city of Calhoun has been sued as a defendant 4 times. In one of those cases, the city of Calhoun, because it's got to clean up its water, filed a cross claim against all of the defendants, which includes Mohawk, which Mohawk's corporate office is in Calhoun. That was very troublesome for the city of Calhoun to take that step. But the city of Calhoun owes a duty to its citizens to provide clean water. And that's what cities that have taken these cases on been out to do, is to provide clean water. The city of Rome in 2019 filed a lawsuit, named the chemical manufacturers and named a number of carpet manufacturers from Dalton because of what was coming from the city of Dalton through the Conasauga, the Oostanala River, the main source of water for the city of Rome. That case was settled. There has not been a judgment against the carpet manufacturers in a Georgia case yet. There are cases pending. So a couple of things about this bill is this bill imposes a get out of jail free card for Mohawk, Shaw, and others, but it has a standard in there which is a very difficult standard if you're going to have a willful misconduct. That's a higher standard than we're normally having to prove. I would suggest that if there's going to be some type of standard of knowledge, that it should not be willful misconduct. It should be knowledge. And make no mistake about it, there has been testimony. Shaw and Mohawk, in part of this, in this notebook, actually one of the documents that Mr. Rogers referred to from DuPont is under tab 7. DuPont 3M, they did not tell the truth to the carpet manufacturers. But in 2001, when 3M came and took PFAS off of the market and met in the room with Bob Shaw of Shaw Industries, Bob Shaw threw a carpet tile at them because he said, "You've put a target on us." But Shaw and Mohawk from 2001 through 2019 continued to use the products, even though they knew that 3M was pulling it, and 3M had said it's carcinogenic. The EPA has said it's carcinogenic. The EPA this past year imposed a maximum contaminant limit on drinking water at 4 parts per trillion for these two chemicals.
Okay, I got to interrupt you here. I have a question for you, Chairman Reeves.
Mr. Davis, thanks for coming and thanks for the notebook. One question I have, you've got LVT flooring, and 85 or 90% of that comes from overseas rather than from somewhere like Dalton, and those folks aren't parties to these cases. Soil was mentioned earlier, which makes me think of agribusiness. You mentioned Calhoun, that drinking water systems are already getting sued. Water and sewer authorities are all over the state. What is kind of the outside edge of the liability and the fallout from these cases? I'm looking at, Northwest Georgia, Metro Atlanta, Savannah. You got these cases sprouting up all over. What is the way to keep, agribusiness and our local governments out of getting sued for these matters?
Well, from a city standpoint, this bill attempts to provide immunity for cities and counties where they don't get sued. But I'm defending those types of cases, and I'm not advocating for that type of immunity because we know what the limitations are. Cities and counties, you talking about being the victim? Cities and counties and water sources, they're the victims. But the ratepayers and the taxpayers are going to have to pay for it. People who are responsible for putting it in the waterways, the chemical manufacturers, the carpet manufacturers, those that have put it, once they knew about it, they are responsible, and that's the way we've looked at it. They've got to pay. The rate, what this bill doesn't do, there are a couple of things this bill is problematic. You take out the receivers, cities still get sued, 3M comes in, DuPont Daikin comes in, we go to trial, and they point to the empty chair under apportionment and say, well, we sold it to the carpet manufacturers, there they are, if this bill passes, you've provided them immunity, and then you have prevented cities and counties from being able to recover from all who are responsible. The other part about that is this doesn't immunize cities and counties from ratepayers, where cities and counties may have to go up on their rates to cover the infrastructure for the PFAS remediation. And so that's why the immunity of this bill is not, it's broad in one sense, but it's very limited. Cities, counties, the same people that elect you are the people that are going to have to pay for the remediation. And city and county water authorities have taken the action to try to make sure that the people who put the chemicals and knew about it are responsible. I would urge you not to pass this bill.
Okay. Thank you, Mr. Davis.
Thank you.
Chairman, if I might follow back as you're waiting on the next speaker, I think it's fair to say what the attorney said just then, except that he actually works both sides of the issue. And when you work both sides of the issue and you're making money on both coming and going, it's a little bit of a disheartening to hear somebody talk about worrying about the cities and the taxpayers, because unfortunately my taxpayers were in his lawsuit in Rome, and it cost my taxpayers $25 million. $25 million for the taxpayers and the ratepayers of Dalton and Whitfield County. So there wasn't concern for the liability of the city who hadn't followed the rules, had no idea. But yet that's why the gentleman before said Dalton Utilities and the city of Dalton has sued the carpet manufacturer. You left them no choice. And I can assure you, just like in Columbus, they didn't want to sue Aflac, but they had to because of the gentleman's lawsuit in Rome for $25 million.
Okay. Amber and Leroy Fletcher. Okay, you're both going to have to use that. You can put that chair up.
You want to sit right here? I'll get it for you.
All right. I still got to limit y'all to 3 minutes. I got a lot of folks that working on
I'm going to let
trying.
her read my testimony too, because she just reads them faster than I do.
Okay.
Good
all right.
afternoon. I'm Amber Fletcher.
And I'm Leroy Fletcher.
We've lived in Dalton, Whitfield County for 40 years. I've raised 6 kids in our home in Dalton. We have 6 kids from the ages of 21 down to 2. We're new grandparents. We love our home, and it's about 5 acres on the creek. It was a wonderful place to raise a family, and part of the reason we bought our house is right by the creek. It was a great place for the kids to float on the rafts and try to do the right thing, have our own chickens and eggs, and plant a beautiful garden with our children with fresh fruits and vegetables. Our home and community have been a great place to raise our kids, and we felt so lucky. But as you can see on this map, our house is directly downstream from the storage ponds at nearby Mohawk plant. Our stream has a direct connection to the Mohawk ponds. Over the past few years, we started hearing more about the PFAS contaminations, so we decided to have our water tested. We got our results, and they first told us our numbers were high. We found out that 4 parts per trillion were high. And on our creek property, the water that backed up, is 7,684 parts per trillion. Our kids play in this water. And our results for our pond came out 81 parts per trillion that we dug ourselves. And our soil results just came back at 32,490 parts per trillion. I took these photos of our children playing in the creek in our property, and what used to be a beautiful family memory brings feelings of anxiety and fear. Until recently, we ate the eggs from our chickens. We've fed off our land. Are the eggs safe? Were they ever safe? Our children played in the creek and the pond. What does this mean for their health? We go to bed at night thinking of our children's potential health issues and our medical bills and what's going to happen to our property value. Can we even continue to live in the home that we love so much? All we ever wanted to do was raise our family on this beautiful, safe property. And Vishal and Mohawk poisoned the water with our property and our neighbor's property, and they must be held responsible. They knew what they were dumping into the water and did it anyways, and for that fact, we need to be held accountable for what they did. Our parents taught us that to be truthful and take responsibility for our actions. Shaw and Mohawk need to take responsibility for their actions. Please don't pass this bill. Thank you.
All right, thank you.
Mr. Chairman, also if you can see, and everybody put a photo, the Mohawk plant is here, just for clarity. That is the Mohawk plant at the top. All right, the blue line is the creek that runs right to their property, which is the red dot, and it flows to the Conestoga River. And that's the water supply for northwest Georgia. But you can tell it directly from Mohawk to their property in the creek that they dump the PFAS contaminant with, the discharge.
Martha Bradford.
Good morning,
Morning.
Mr. Chairman, committee. I appreciate you giving me the opportunity to be here today. I am one of the situations in Dalton to where our family had direct fallout from me playing in these contaminated creeks as a kid, and my husband being an industrial electrical engineer and working in all of these Shaw and Mohawk plants in Dalton. We have been married 43 years, and during those 43 years, my husband had never had anything but a cold and a hay fever attack. He was always a very healthy, fit man. I myself, from a very early age, when this PFAS stuff first coming around, I worked in the carpet industry. I worked in the claims divisions of carpet industries. I worked on boards of directors with Ed Berman from DuPont. I lived in a 3-mile radius of a DuPont storage facility in my neighborhood. I currently live in the south end of Whitfield County, where I've been since age 5. My husband never left his whole entire life. We live on a 186-acre farm, and I do have some things about the agriculture, but however, because of my time, I'm going to try to rush through this. As I stated, we have resided on the south end of Whitfield County most of our entire lives. As a child, my neighbors and I played outside during the hot summer days. We would play in the creeks and streams that ran through our neighborhood. And those creeks and streams that ran through the neighborhood were direct from the creeks that ran from Mohawk plants all the way down to the estuaries into the neighborhood that I lived. Around the age of 7 until I was 19, living at home, I suffered from extreme urinary tract infections, bladder infections, kidney infections. I had blood clots at a very, very young age and had to have surgery for them. I've had a hysterectomy because of uterine cancer. And that was at age 23, and it was found the night my daughter was born in 1984. I had kidney cancer. I lost my right kidney to cancer in June of 2000. And I am a current patient now at Emory University Hospital with specialists there that are trying to control and figure out what this mystery illness I am currently dealing with. And I'm sorry if my voice sounds weird. It's just part of this disease. At that, you know, the cost, this last disease has cost me at my livelihood. I may be 60 years old, but I've got thought I had a lot of good years in me. I'm unable to work now, and I've had multiple hats through my life that I'm very proud of. I love my community. I love everyone there is, but most days I can't even stand up and walk. I can't even get out of the bed because of this issue I'm battling now. The bottoms of my feet burst open, and with absolutely no medical reason at this time, my shoes filled with blood, and another doctor visit back to Emory for them to tell me we are still at a complete loss. My husband, on the other hand, John Bradford, is 72 years old. As I stated, he was an industrial electrical engineer, worked in all of these plants his whole entire working career. His last being Lyerly, Georgia, Mohawk plant. His grandparents built the home that we live in 1905, raising multiple children. Yes, sir. My husband's entire working career, as I stated, was spent there. My husband now has been diagnosed with 4 rare diseases. He was contracted through Mohawk to come in and take over for an electrician who suddenly died, and my husband stepped in as a contractor. He worked there in the Lyerly plant for 2 solid years. In 2 solid years, he took 10 days off, and then one day he came driving in because they had to bring him in. He collapsed at work, and he's a totally healthy man. In the long run, he was sent emergency directly to the hospital. From the hospital, we were sent directly to Emory. He was admitted at Emory. He was diagnosed within 3 days of 4 rare diseases that took him completely down. He almost died the day we had him there. And as a result of this, we have been fighting this daily. He has recently been diagnosed on top of this as Parkinson's disease, and now on Monday we are going for him to have PET scans because he has had multiple tumors that have came up inside of his body. And if I told you the 4 rare diseases, I'm sorry, sir. I just wanted to get this across.
I understand.
I'm with everybody. I don't support this whatsoever because of a lifetime of what my family has had to endure and the expenses that we've had to endure. But I want to be able to work with everybody and let everybody know we need to try to get this cleaned up, and don't let people be immune to the ones that do have the knowledge and know, because I worked in corporate claims. Things came across my desk, and I did see things. And I also worked in INSCO Environmental Protection Agency in Dalton, Georgia's office manager, and we did toxic waste storage for Mohawk.
Thank you, Ms. Bradford. I appreciate it.
Thank
Ronnie Anderson. Do we have Ronnie Anderson here? Oh, I'm sorry. Okay.
Thank y'all for letting me testify before you today. My name's Ronnie Anderson. Let me pull that down for you, and I've lived in North Georgia since 1963. I worked at Shaw for 45 years. As my job at Shaw, I worked in the dye house. They run 24 dye banks, 24 hours a day, 7 days a week. Hundreds of thousands of gallons of water was dumped right out of that plant into a stream that was beside the plant. And that stream flowed down to a swamp behind the plant. Beside that swamp is Dalton Utilities wastewater treatment plant. And over the years, I worked different jobs at the plant, and they moved me to the sample department where all these chemicals was in the carpet, and they cut the carpet up into samples with no good ventilation, all the lint chemicals floating around in the air, and no mask, no talk about the chemicals that's in the carpet or anything else. And the levels of PFAS in the Consolidated River is what concerned me the most, because me and a friend of mine grow a 6-acre garden right on the side of the river. It was tested at 225 parts per million. Just north of that, Dalton Utilities pulls the water out, drinking water out for the county. Mohawk and Shaw is responsible for poisoning my garden, my neighbor's land, and the drinking water. Because of this problem, my health is ruined, and my property values will be going down. I'll probably have to move. My whole life, I lived there. I don't want to leave, but I probably will have to. They say the carpet industry says they didn't know the chemicals was there. They should not have dumped it out in the water. And they say it's not their fault. Yes, it is their fault. And most of the people in the sample department that I worked with, about 85% of them has died from cancer. From all this stuff. And they can't say they didn't know it was bad. If they didn't know it, why did they dump it out into the water? I've seen it dumped myself.
Okay.
That's all I have.
Thank you, Mr. Anderson. I appreciate it. All right, Jesse Dimmonbrun Chapman. Hope I said that right. Okay. Mark Rogers, you've already testified. Brittany Hull.
Good morning. Thank you, Chairman Gunner and committee, for hearing this bill, and thank you, Chairman Carpenter, for bringing it. My name is Brittany Hull. I'm Vice President Governmental Affairs for Georgia Association of Manufacturers. Today I'm here asking for your support of House Bill 211. Georgia is home to approximately 10,000 manufacturers who employ roughly 435,000 people across Georgia who rely on industry to provide for themselves, their families, and their communities. Manufacturers deliver jobs with above average wages and benefits and support numerous businesses outside the manufacturing sector. The manufacturing industry generated a total revenue for the state of Georgia of $77.2 billion in 2023, accounting for 9.6% of Georgia's economic output. Our state's manufacturers range from small shops of 2 to 3 employees up to 10,000 employees. The PFAS Receiver Shield Act is a forward-thinking bill that aims to safeguard our state's manufacturers who find themselves using or handling PFAS in their daily operations. Unfortunately, many of my members are being drawn into lawsuits over something they had no control over. Our members were sold products containing PFAS. They were told products with PFAS were legal, met EPA rules and regulations. They used the product deemed legal and as such should not be held liable. House Bill 211 would protect GAM member companies from meritless lawsuits. In conclusion, House Bill 211 is a forward-thinking legislation that supports the manufacturing industry in Georgia by providing necessary legal protections and promoting economic stability. We urge this committee to pass this bill to ensure continued prosperity of our state's manufacturing sector. Thank you, Mr. Chairman.
And thank you for keeping it within the time.
Yes, sir.
All right. Okay. Michael Edwards?
His letter is in your package. He was unable to attend.
Trey Paris.
Point of order, just inquiry about the plans, given that it's 9 o'clock and school is starting.
Those of us that are on rules, I'm getting ready to take off and go up there. Vice Chair Reeves is going to go as long as he can. Just to give people a chance to talk. And then
2 minutes.
2 minutes? Okay.
Is it the intention to take a vote? It just puts members in a really tough position to not be able to vote.
What do you want me to do? I'm trying to get to let everybody have their say. And I mean, we may not get to a vote today. I don't expect we will. No.
If we could have that commitment from the chairman, I think it would help members plan how to prioritize which committees to go to.
I just need a quorum of 5 people. So those that need to go to committees, go. I'm not holding you here. I'm getting ready to leave and go to rules.
With respect, Chairman, I understand you're not making us stay, but speaking for myself, I feel responsibility to this committee, and I don't want to leave, but I also don't want to shirk my other responsibilities. So, but if there's not going to be a vote, then it's easier to decide how to allocate time. But if there is going to be a vote, I think some of us feel we should stay.
Let me. I'll assure you there won't be a vote.
Okay. Thank you, Mr.
This will be
Chairman.
hearing only.
Thank you, Chairman.
Okay. All right. Trey.
Thank you, Mr. Chairman. Good morning, everybody. My name is Trey Paris. I'm with Freeman Mathis Decisions, and I represent the Georgia Paper and Forest Products Association. I want to thank you, Mr. Chairman, and also all the committee for hearing House Bill 211, and we appreciate Chairman Carpenter and his colleagues for sponsoring this bill. I'm speaking today to respectfully ask for your support of HB 211, the PFAS Receiver Shield Act. You've heard from others detailing their support for HB 211, so I'm going to be very brief, and I'm mindful of your timeline. This issue is important to the paper forest products industry. They have 177 facilities in Georgia, and they employ more than 50,000 people with an economic output of more than $20 billion annually. In short, their industry is vital to the success of rural Georgia, and the industry faces many challenges. The price of fiber, labor, energy, transportation, not to mention both domestic and foreign competition. PFAS litigation is now another challenge. The industry is being pulled into lawsuits, even if companies and their products do not meet the definition of PFAS manufacturer. The paper and forest products industry is a prime example of a PFAS receiver. They were sold these products that were legal and met EPA regulations for incidental use in their operations. Their industry uses recycled paper and recycled paper and cardboard to make new products, toilet paper, paper towels, packaging, and the like. However, the recycled paper coming into the mills could contain PFAS without their knowledge. The inks used in newspapers, the print on food packaging, these could be all potential sources. Representative Carpenter's bill recognizes the difference. HB 211 is good public policy that would support the paper and forest products industry by providing necessary legal protection so they can continue to grow and prosper. We respectfully ask the committee to pass this bill. Thank you very much.
All right, got a couple of questions. Vice Chair.
I don't want to put you on the spot on a legal question. It may be a rhetorical question, but the apportionment issue and the empty chair issue, that's something that I think is a real issue. Does anybody can you find some language to address that issue, that if a Georgia company is provided protection under this bill, that the large international companies won't be able to point to an empty chair and get off the hook through apportionment issues?
I'd have to look into that, but yeah, certainly. Thank you.
Representative Oliver.
Thank you, Mr. Chair. It's helpful that I'm hearing this morning from other large manufacturers. It tells me more about the depth, the scope, the big deal that this bill is. Do you really think Georgia should be the only state that grants total immunity?
I'm sorry.
Do you really think Georgia should be the only state that grants total immunity, given the status of all this national litigation?
I can't speak for what other states are doing, but this is obviously, as you say, a problem that's not just confined to Northwest Georgia.
Thank you.
Thank you.
Mr. Paris, I think Representative Kelly has a question for you.
Thank you, Mr. Chairman. Trey, thank you for being here. Thank you for the work that y'all do for our forestry industry. Y'all are vital to our state, and so is our agriculture community. And I understand how important y'all are. So I think everybody in this building understands. And if there's something we need to do to help y'all, we generally do it. And so my question is was the governor approached about putting this in his tort reform measure this year?
Representative, I really can't speak to that. I do not know that, but I will try to find out if that was broached with him.
Thank you.
Not aware.
I can answer that question. I reached out to the governor's team when Aaron Brockovich showed up in Whitfield County. I understand the gravity of this situation, and I understand that this is a big issue around the United States. I get it. It's a big one. And we don't want, a lot of times people don't want to be out there on the forefront on issues. I understand that. But if you don't get out in front of this issue, at the end of the day, legacy manufacturing around the state will be put at a significant disadvantage and be run out of business. And then your stuff's coming from overseas and you got no control over it. That's the reality.
No more questions for you, Mr. Paris. Brant Lane.
Thank you.
Mr. Chairman, I'm actually Russ Pennington.
Okay.
Brant couldn't make it today.
All right.
Brant works for Hodges, Harbin, Newberry, and Tribble, a consulting engineer in Macon, and I'm a consultant to Hodges, Harbin, Newberry, and Tribble. Representative Carpenter added an amendment to the bill on consultants and engineers specifically that work for those manufacturing companies and the endpoint users, so the landfills, water plants, wastewater plants. And so I'm a consultant engineer as well, and I was a professional witness for a case in Alabama that impacted directly Hodges, Harbin, Newberry, and Tribble. There was a water plant that had PFAS contamination. They were looking at all the sources of that water plant, the root cause of the contamination. So it went upstream to a wastewater plant where that was determined to be the source of the contamination, and then cast the net out further and it was determined that the landfill that was upstream of the wastewater plant was also a source of the contamination. A circular process between the waste from the landfill to the wastewater plant back to the landfill as well. Hodges, Harbin, Newberry, and Tribble was a consultant to the landfill. Had nothing to do with the water plant or the wastewater plant. It was the leachate collection system. So in essence, the runoff and the stormwater that's collected at the landfill. During the discovery process, Hodges, Harbin, Newberry, and Tribble came up with the word leachate, and so they got brought in as a defendant in the case. My client felt very strongly that they were brought into the case because they were identified as having a professional liability policy, and they had to pay out to the max of that policy, and it also costs the principal personally as well as an additional payout. As a result of that, their liability company or their insurance company canceled their policy. They got a new policy. It cost them 3 times what it did the previous year, and it's about 1/3 of the coverage that they had previously. So this is a real issue for consultants and engineers, and I encourage you to take consideration. Thank you.
Thank you. Any questions for Mr. Pennington? No questions. Wes Robinson.
Sit right here. Thank you.
And Carrie Miller.
Yes,
we'll kill 2 birds with 1 stone.
If it's easier.
You want 3 minutes or 6?
No, we'll try to fly through this, Mr. Chairman. My name is Wes Robinson with the American Chemistry Council and Executive Director of the Georgia Chemistry Council. I'm joined by Carrie Miller with the Robbins firm as outside counsel. So we represent the chemical manufacturing industry here in Georgia, and I wanted to kind of clear up a few things. I'm trying to keep it really high level and not technical, but I think it's really important for the committee to understand when we're talking about PFAS, that's not any one thing. That's a class of chemicals, just like a hydrocarbon, where you could have plastic, propane, the alcohol in your bourbon, all in that same hydrocarbon class. Those are all going to have very distinct properties. They're going to have very distinct risk profiles. The same is true of PFAS. And most of the conversation that I've heard today has really been around 2 of the hundreds of chemicals that are in commerce today. And in fact, the 2 that have been mentioned are no longer manufactured in the United States and are only manufactured abroad. So those 2 aren't even manufactured here anymore. And I think that's really important because these can all be manufactured and used safely. And while some entities like the carpet and textile manufacturers may be able to phase out the use of PFAS, it's essential for the manufacture of many products, whether it's aviation, whether it's autos, the AC system in your car would have it, inhalers, medical devices, and the list is on and on and on. So you can see why our industry would have such grave concern with this legislation when tens of thousands of different products would have broad liability when only their suppliers, our members, would have any of that liability. Also, we've seen a number of pass receiver bills introduced around the country and also debated in Washington, D.C. They almost always only focus on POTWs, so publicly owned treatment works, and entities like landfills. Never have they had downstream manufacturers who are actively profiting from the use of PFAS while their suppliers hold that liability. And lastly, we think that if you were going to grant them liability, the standard used in this bill with willful misconduct is extraordinarily high, right below criminal negligence. And so happy to answer any questions. Try to go very quickly on that. And, we're here to be a resource to y'all and appreciate your consideration of our viewpoint.
Mr. Miller, anything to add?
Yeah, Mr. Chairman, I'll be very brief. I know lawyers are notoriously bad at estimating their own time, but to answer a couple of questions here, I've heard a couple different times as to whether other states are acting on this. My research is I've seen it proposed in 5 other instances, all limited to the situations that Wes was referring to about the truly passive receiver, none of which have ever been enacted. Separate from that, there's been appropriations, things like that, for those type of water treatment facilities, et cetera. The second issue that hasn't been addressed that I do think bears this committee's attention is with respect to the applicability to the claims and the temporal scope of that applicability. As many of these committee members are aware, generally speaking, retroactive legislation is heavily disfavored by the courts, but it will be found to the extent that it's necessarily implied. Here you have a bill that presents, with respect to EPD, that it does not apply or only applies to claims arising on or after January 1, 2024. That then necessarily implies that the rest of the immunity grant is intended to apply to, say, a currently pending claim or a claim that may have previously accrued. That matters for our folks with respect to the cross-claim situation. I don't think that is necessarily an intent or an awareness of the committee, but it creates a due process issue because a cause of action is a vested cause of action is a property right that cannot be rendered nugatory by a substantive issue. Finally, I won't belabor the point on the willful misconduct, but I will leave you with one fact pattern with respect to that definition. So say XYZ textile mill is receiving a PFAS chemical to apply to products that they're in turn marketing and selling. XYZ is placed on notice from the supplier or vendor of the need to containerize and then incinerate the wastewater that is containing the PFAS that is used in the process of the washing and dyeing. The XYZ does not do so. 10 years later, they're sued. They take an action which solely requires hooking up a hose and placing the wastewater into a containerized box. Is that inaction for failing to containerize, once placed on notice, does that fall within your willful misconduct definition that's before you? I submit to you, I don't believe it does. It doesn't pertain to an action that was taken, pertains to an inaction, but it's the type of situation that would be subject to litigation, subject to a summary judgment motion as to whether it was foreseeable, whether the person was on notice. Mr. Chairman, I'll leave it at that. Thank you.
Any questions for Mr. Robinson, Mr. Miller? I have a question. It sounds like some of the witnesses earlier were saying that this bill is too broad. Am I hearing y'all correctly that the bill's too narrow? That you think that chemical companies should get protection also?
We're not asking for that.
Okay. All right. Thank you.
And to put a finer point, I think the issue becomes when the chemical company has provided a product that is then used and applied by the manufacturer to a product that's sold into commerce that's demanded by the consumers for the stain-free protection, et cetera, that results in the profit of the manufacturer. It shouldn't be solely the chemical manufacturer liable for the downstream use when there is notice of the need to apply or use in these certain situations.
All right, thank you. Julie Allen.
Thank you for the opportunity to speak before this committee. Please note that in your folders there is a handout, and I'll read what I'm going to say in order to be brief. My name is Julie Allen. I'm a former candidate for House District 57 opposing committee member Stacey Evans. I'm her constituent. While we may disagree on some issues, protecting our children's health is not partisan. When RFK Jr. suspended his presidential campaign and joined President Donald Trump in launching the Mohawk movement, he stated the only thing that will save our country and our children is if we choose to love our kids more than we hate each other. So I'm here to speak in urgent opposition to HB 211. I ask you to protect Georgia families from toxic chemicals and oppose shielding corporations with HB 211. Why is this committee considering legislation that essentially grants a preemptive pardon as Biden did for Fauci? Why is this committee entering into the judicial process? I strongly oppose HB 211 legislation that shields corporations from the devastating health impacts of PFAS. This bill, along with SB 144 and HB 424, jeopardizes the health of Georgia families, farmers, and future generations to safeguard corporate profits, even as cancer rates rise, infertility increases, and birth defects proliferate. If passed, HB 211 would shield these entities, receivers, from certain lawsuits related to PFAS contamination, even though they may contribute to PFAS pollution through handling, disposal, or use. This could make it harder for affected communities to hold polluters accountable for water and soil contamination. The purpose of the courts is to determine liability, not the legislature. There's mounting evidence of harm. PFAS and pesticides pollute Georgia's water, soil, and food supply, threatening communities and farmers. These are not theoretical risks, they are real, documented crises harming Georgians now, as many have testified here. Yet HB 211, SB 144, and HB 424, other bills under consideration during this legislative session, block the legal recourse needed to hold manufacturers accountable. Our nation is facing an unprecedented health crisis. 74% of Americans are overweight or obese. Childhood diabetes is at record levels. Autism rates have surged from 1 in 1,500 in 2000 to 1 in 36 today. The CDC reports the U.S. has the highest chronic disease rate on earth. Cancer rates among young adults have increased by 79%. Mental health disorders are rising. 40% of teens are diagnosed, and 15% of high schoolers are on Adderall. HB 211 prioritizes corporate profits over public health at a time when we should be addressing this public health emergency. I urge you to vote no today, or whenever it is, on HB 211. I also urge you to reject HB 211 along with HB 424 and SB 144 from consideration on sine die, and stand with Georgia families, our children, farmers, and future generations by rejecting these dangerous bills and protecting public health. Thank you for your consideration.
Thanks, Ms. Allen. The other bills you mentioned, those were big pharma bills and pharmaceuticals and things like that, not in this committee, right?
Correct, but they are liability shields, and I beg you not to bring them into the portfolio of what's considered for sine die.
Be sure to go be heard by those committees if they take up those bills.
Thank you.
Thank you. I believe that's the entire list of people who signed up, but we're here for 211, Representative Carpenter's bill. Does anybody else want to be heard on this bill? Anybody going once? Going twice?
EPD's here to talk.
Okay. Would you like to testify? Thank you. And by the way, since I'm not in rules, for all the auctioneers out there, you were coming out of the professional licensing bill. The status quo will be maintained. It's going once, going twice. Thank you for coming.
Thank you, sir. Members of the committee, appreciate you all giving a chance for EPD to provide just a little bit of context about the regulatory landscape. So I'll provide just a very brief overview, and then if you have any questions about the regulatory landscape, I'll be happy to answer those.
Thank you. For the benefit of those who don't know, if you'll state your name and position with EPD.
Yes, sir. So my name is Anya Trishtinsky. I'm the chief of the Watershed Protection Branch with Georgia EPD. So I've got all of the water programs underneath me, and while there were some references to Superfund and CERCLA, toxic release inventory, and other things that EPA really focuses on, a lot of that is capture and regulation, not delegated down to the states. A lot of the active litigation right now and a lot of the active research on PFAS is sitting in the water arena, specifically on drinking water and the risks from PFAS exposure through drinking water, as well as on the wastewater and water quality side, sort of figuring out how much PFAS could be discharged into streams and rivers and what discharge limits may need to be for dischargers in the future. EPD has delegated authority under the Clean Water Act and primacy under the Safe Drinking Water Act. So what we do is we look at EPA for doing the technical work, promulgating regulations, and then we utilize our regulatory process to promulgate rules that are consistent with the federal requirements. So for example, you heard today that EPA published final rules for maximum contaminant levels for PFAS in drinking water, and it was focused on a narrow class of PFAS, but identified these numeric limits that public water systems would need to meet. These rules were promulgated in April of 2024, and as a state that wants to maintain full primacy under the Safe Drinking Water Act, we have until April of 2026 to promulgate our own regulations that are going to be consistent with the federal regulations. We understand that these rules are subject to litigation right now. However, there has been no stay in any of the cases related to the maximum contaminant levels, and as a result, that timeline still holds. On the water quality side, EPA has made a number of moves. 2 of them have been delayed. One, to protect human health. So human health criteria were developed by EPA. These levels are what you're supposed to find in streams and rivers, kind of flowing waters of the state. These levels are very, very low, much, much lower than the maximum contaminant levels for drinking water. So EPA extended the comment period. This is just a proposed rule, and we're looking at what comments will come in. Also, before we can include monitoring requirements in our discharge permits, those monitoring methods have to be promulgated as rules by EPA. EPA proposed rules that would include methods for testing for PFAS in these types of discharge permits. Those rules are also proposed, also in public notice, and the comment period was also extended. The only final rule that's in effect right now is for aquatic life criteria. This is a type of water quality standard, you know, how much PFAS or how much of a particular pollutant can be in a water body and still support aquatic life, like fish, mussels, shellfish, things like that. Those went final in October of 2024, and EPD will be reviewing those rules and then moving with any regulatory changes of our own in the next 3 years using a process that's called the triennial review. So that's the requirement of the Clean Water Act. We update our rules every 3 years with these recommendations from EPA. So right now, there are no Georgia-specific regulations for PFAS. Now, we have been able to address PFAS through our general criteria, because we do have general requirements to keep the waters of the state clear of toxic or harmful pollutants of all sorts of different classes. So we do have some regulatory authority that exists, and we are in the process of following what EPA is doing and making the necessary updates to our rules and regulations to stay consistent with these delegated programs. With that, I'll take any questions you might have.
Thank you. We do have some questions. Chairman Smith.
Thank you for being here. Just from experience and offline dealing with different issues with EPD, I thank you for your all's work, but what I run into with the state, I don't have much faith in the federal government and what they do, because depending on who's in office, it's going to change every 4 to 8 years, or if that quick. My issue that I've ran into is that you really need more teeth in the law through statute to be able to protect citizens when y'all actually discover these issues. And I've discovered, for whatever reason, whether it's a special interest under this gold dome, have kept the teeth from being given to deal with issues like that. And so y'all have this discovery of just how bad it could be. Do y'all even have the teeth necessary to do it, or could you use even more to, sharpen those teeth, so to speak, to deal with these issues?
Yes, sir, and I appreciate the question. I think that we have a really good enforcement process already set out in statute. So we are directed through statute to try to get compliance with environmental regulations through conference, conciliation, and persuasion. And we find that in the majority of cases, we can work really effectively with companies, with local governments, with the folks that we regulate to get to compliance, because our goal is always to get to compliance. Where we have found things to be tricky is when we are sometimes in this intermediate area when regulations are being developed but not fully proposed. And that's when our general criteria get really helpful. We are able to take moderate and effective enforcement action to get compliance and get improvement. So for example, we had a no penalty consent order to address a local issue of PFAS within a public water supply watershed. And we found that we were able to work very effectively with our existing authorities and the existing rules on our books.
Thank you.
Representative Kelly.
Thank you, Mr. Chairman. Thank you for being here with us today. I appreciate the work that EPD does and why we have you. It's to help protect our state's natural resources, our streams, our water, our ground. And I generally view when I'm debating measures like this, where there is some bad actor, I think we can all debate who the bad actor is in this situation. But when we're debating this, I always view it as you either got to have a very strong regulatory core to hold bad actors accountable, or you got to have a jury system that holds bad actors accountable. And I generally feel that when you have good actors and bad actors, a lot of times when you look at the regulatory side, good actors get punished for the actions of the bad actors. Is that fair? Does that happen sometimes?
I can't say that it would never happen, but I know that our intent is to understand that there is a difference between the bad actors and the good actors, and we through our enforcement process that takes that into account. So we have explicit requirements when we do, for example, a penalty calculation to look at how folks have worked with us, what efforts they've already made to remediate the problem, whether they were aware of the fact that they were causing an environmental issue or not. And we're able to take all of these things into consideration. And as a result, we ultimately end up, again, we're always going toward that goal of compliance, but the pathway there ends up looking very different for bad actors versus good actors, based already on things we've got baked in to try to make sure we've got that appropriate differentiation.
What does that process look like? Are there open hearings or in comments from the general public? Do y'all have EPD hearings where people are brought before an administrative law judge or someone like that?
Yeah, let me give a broad overview of our enforcement process. And one thing to keep in mind is that we can kind of start anywhere within this process, but we always try to start at the lowest level possible because we want to try to build that cooperation and working to our common goal of compliance. So when a violation is identified, say through an inspection or a complaint or report that's submitted to us, we review the violation, pull all the documentation together, and then if it's something simple, we can resolve it with a documented email or phone call, like, hey, your report is late, please go ahead and send it in. Or we request send out a formal letter, either a letter of noncompliance or a notice of violation that requests specific information from the permittee and a bit more, or the regulated entity, or a bit more back and forth to figure out a good plan to get into compliance. In some cases, the letters are unsuccessful, or in other cases, we're looking at an issue that's pretty significant. And we start with something called a consent order, which is basically a negotiated settlement between the regulated entity and the director of EPD. It's signed by both parties. It outlines the violations, and it outlines a penalty if there is one, as well as all the steps necessary to get into compliance. These consent orders are actions of the director. There are specific circumstances under which they are public noticed, but not all of them are. And as an action of the director, they are subject to challenge. So if someone sees a consent order that they don't like, they can either submit comments if it's one of the ones that's public noticed, or they are able to actually bring forward a challenge through the administrative law process.
And just a couple more questions, Mr. Chairman. I know we're,
This is an important issue. Ask your follow-ups.
Thank you. Does the EPD acknowledge that PFAS chemicals cause cancer?
We follow the science that's generated by EPA and the language that EPA uses around PFOA and PFOS, which are the two long-chain PFAS chemicals, ones that are best understood and whose health effects are best documented. They use the language of likely and probable carcinogens, so that is how we look at it as well. Yes.
Likely and probable. How do you get those chemicals out of the water?
So there are a couple of different ways that folks have started to get those kinds of chemicals out of water. The two most common ones are to use activated carbon, either in a granulated or particulate form. It's basically an additional filter you can put into a drinking water plant or at the end when you're finishing up your wastewater. Another option is reverse osmosis. This is a very intense and can be a very expensive process to implement. If you are familiar, for example, with the city of Rome, they've been working through putting in a reverse osmosis process in their drinking water plant, and that tends to pull out all of the PFAS.
How many consent orders has the EPD, back up, how many complaints has the EPD had generated on PFAS chemicals?
I would have to pull. We have a complaints database. They tend to go to the district offices, but if that information is helpful, I'll be happy to go and pull those records.
How many consent orders has the EPD entered into based on PFAS chemicals?
We have had one, to my knowledge. It was a no penalty consent order intended to be protective of a public water supply.
Which public water supply?
It was the Raccoon Creek watershed that is used by the city of Somerville.
How was that complaint generated?
The complaint was generated because monitoring data collected by EPA and then confirmed with EPD identified levels of PFAS in the Raccoon Creek watershed that were above the health advisories at the time. At that time, it was 70 parts per trillion, and the amounts in Raccoon Creek were getting up around 100 parts per trillion. When we looked at what was occurring and what sources were potentially there in the Raccoon Creek watershed, we identified that the neighboring town of Tryon had been applying biosolids, which are kind of the solids that are left over after wastewater treatment, in that area. And so we worked with the town of Tryon to find an alternate disposal for their biosolids and cease the application to be protective of Raccoon Creek.
How expensive is it to put in one of these water filtration systems?
So a granulate activated carbon or particulate activated carbon is much, much less expensive than reverse osmosis. I'd have to go and double check the specific numbers, but those tend to be something that is achievable for most drinking water treatment plants. However, it's going to be very site specific, and that approach really only knocks down the PFAS so much. Reverse osmosis is a more powerful treatment. It can address higher levels of PFAS. That is a very expensive process to put in.
What is the percentage of water treatment facilities in our state that could be affected by PFAS?
So we have been collecting data independently, and we've also been getting data from EPA. They're doing a survey of a large group of public water systems, and we are seeing between 30 and 40 or so public water systems so far that are affected by PFAS to the extent that they are likely going to be installing treatment or identifying some alternate sources of water.
Do you have an idea of what the cost would be for the taxpayers to install 40 new water filtration systems?
I do not. The systems are very, very different, and the amount of PFAS that they are treating varies as well. So these are going to be numbers that are still getting generated by those public water systems as they themselves work with their engineers and find the appropriate option for their specific site.
Thank you. Is there anything that would prohibit you bringing us a copy of all the complaints generated regarding PFAS levels?
No, sir. I can work to get that pulled.
That would be helpful. Thank you.
Any more questions? I have a question about the European standards for PFAS. I've heard there are differences in the way that Europeans measure PFAS versus how we are doing it in America, and then you mentioned Georgia hasn't yet developed our standard. Not that we particularly care, but since this is cutting edge science, can you enlighten us on differences in how PFAS is measured overseas?
So I don't have the specifics on how the European Union or European countries are monitoring PFAS. I know that within the U.S. there was a lot of work that was done around the development of various methodologies and tools, and I understand that the work on the analytical side is still very cutting edge. So there are approved methods for measuring PFAS in drinking water, and those approved methods continue to get refined as you get lower and lower levels of PFAS and better specificity, or better and better ability to discern that PFAS exists. You start to have a little bit of difficulty differentiating between species of PFAS. So there's this balance between, we know that we've got 1 part per trillion of PFAS, but how much of that is PFOA versus Gen X versus something else is something that, as you get to that really low level, gets a little bit fuzzier, and folks are continuing to work on that. EPA also has been working to get that method approved. It's called 1633A to measure PFAS in wastewater, biosolids, ambient waters like groundwater, surface water. And that went through 4 drafts before they were able to say, okay, we're really happy with how effective this is at actually measuring PFAS levels. When I talked to the EPD lab manager, especially as you get to those very, very small levels, he mentions that it is as much art as that point as it is science. This is something that's still very much in development.
Chairman Smith.
Did it take the Europeans and all of their supposed knowledge to inform us that throwing washing machines in the creek wasn't a good idea anymore?
Raccoon Creek.
No, sir.
Okay, thank you.
Thank you for providing the information to the committee that Representative Kelly asked and for testifying today.
Yes, sir.
Any other testimony on House Bill 211? All right. With that, we'll close out 211, and I'll announce that Representative Seaball does have a substitute on House Bill 183, which will not be heard during this hearing, but I believe he's ready for it to be heard when the hearing does get called. I'd refer you to Representative Seaball if you're interested in that bill to take a look at his sub. Thank you.
Do you have a copy of the sub? Is it available?
I would be glad to give it to members, and I asked him, have not heard back from him about further distribution, but I'd be glad to get it to our members for review.
Thank you.
Thank you.
Thank you. Sorry to hold you up this morning, guys.